and polity. There is an overlap in your syllabus, and whatever I'm taking today for AP is under Indian polity, but they are common topics. So let me finish. It will be completed for both the AP and Telangana batches. Social issues and polity. For example, I'm first going to deal with SC/ST Atrocities Act. For y'all, you have it in social issues. For them, it is there in polity. Okay. And then RTI Act. For Group 1 TS, you have this under governance. Okay. Group 2, it comes under fundamental rights, and for AP, it is there under polity. Then I'll talk about Lokpal and Lokayukta. And then we are going to discuss all constitutional, non-constitutional bodies for different communities like SCs, STs, BCs, women, and so on. These we will discuss for today. This is what I intend to discuss for all of you. Now let's start with SC/ST Atrocities Act. SC/ST Atrocities Act. SC/ST Atrocities Act, famously known as SC/ST Atrocities Act, otherwise it is called as Prevention of Atrocities on SCs and STs. Okay. Now I am going to do this in the form of questions and answers so that you understand how questions will be asked. Please do not write. First listen. This act is basically made for giving effect to two provisions of the Constitution. One is Article 17, which abolishes untouchability. Okay. So the first question that I am giving you is, why is this made? Constitutional basis for the law. The second is Article 23, which abolishes bonded labor. Okay. Because bonded labor, we find it more prevalent in STs and SCs, whereas untouchability is exclusively found against SCs. So basically the SC/ST Act enforces the provisions under Article 12 and 23. This is the constitutional basis. Okay. Now let's look at the backdrop. The backdrop history of this is, see, initially after 1950, when our constitution commenced, the constitution since beginning had these two articles, 17 and 23. In order to give effect to 17, the first law that was made was called as Prevention of Untouchability Act 1955. Okay, Prevention of Untouchability Act 1955. The basic purpose of this act was to define what is untouchability and then give punishment for practice of untouchability. But what happened was, this definition was very, very narrow and the punishment was very less. There was an increase in incidence of untouchability against SCs and STs, because of which it was amended and renamed as the Civil 1976. Okay. Now if you notice, from untouchability, see, when you say prevention of untouchability, you are not giving anybody a right, you are only safeguarding them from a practice called untouchability. From there, we have made a shift to Civil Rights Act, where you are saying not being treated as untouchable is a right, a basic right of human being. So in this act, they basically widened the definition of untouchability and the punishment was increased. However, this measure was also a failure, after which they made a new law in 1981 called the Prevention of Atrocities against SCs and STs Act 1989. So the basic reason for making this law is the failure of the previous acts, failure of the Civil Rights Act. Because of the failure of the Civil Rights Act, they made a new law to address problems related to SCs and STs, and they used the word atrocities. The word atrocities has a lot of significance. Now, what do you mean by an atrocity? How do we define atrocity? Yes? What is the definition of atrocity? What do you mean by the word atrocity? Yes? Huh? Practice? Loudly. It is not a legal term. How do you define atrocity? What is the meaning in English of an atrocity? We say that is outrageous, atrocious. So what do you mean by atrocity? It's not a challenge. Violence, but how do you define? It is a superlative degree of violence. So basically atrocity is, can be understood as the most inhuman treatment meted to a person. Nothing can be more heinous and inhuman. That is called as an atrocity. Now the use of this word itself indicates that they have broadened the scope of the word. They just don't define the word untouchability, but they also explain the different forms of untouchability. And these forms are categorized into civil offences and criminal offences. The reason why it is categorized so well, and civil offences are again categorized, the reason why they do this is, they should be graded punishment. The more heinous the form of untouchability, the more will be punishment. Okay, till here you please make a note, then I'll tell you about the purpose and the provisions of the Act. Finished? So if at all they ask you a question as to why this was enacted, your answer should be failure of the Civil Rights Act 1976. Okay, now the next thing that you have to know about this law is what is the main purpose of the act, and then what are the key provisions of the act. Now, the first question, what is the main purpose of this law? The main purpose of this act is two. One is, it talks about prevention of atrocities against STs and SCs. And second, it talks about protection, relief, and rehabilitation to victims of atrocities. If you remember this, it is very easy for you to remember the provisions. Now, when you say prevention, automatically prevention, the first step is to create. And when you say awareness, you need a specific person to create this awareness. So it basically provides, under provisions, we talk about appointment of a special officer. Okay, when you say protection, relief, rehabilitation, protection to the victims once they face an atrocity, relief and rehabilitation indicates that there will be punishment to the offender. It indicates that there can be compensation to whom? To the victim, because you know, for rehabilitation you need compensation, for relief you need punishment. Okay, and protection and relief also happens through the establishment of special courts. Because what is the purpose of a special court? When do you call a court as a special court? See, the meaning of special court is, whenever you say for this law we have a special court, the meaning is this court will take only cases related to SC/ST atrocities. What is the benefit of this? When you say special court under the SC/ST Atrocities Act, the only cases that the special court will take will be cases filed under the law. So what is the benefit of this? Speedy justice. It ensures speedy justice. Okay, and establishment of special court is mentioned under the purpose. It says protection, relief and rehabilitation of the to victims of atrocities by establishing special court. So the purpose is two. One is prevention, the other is protection. Make a note of the purpose, then I'll come to the provisions. If you understand the purpose, I'm telling you now, the best way to remember a law, study the provisions of a law, is you understand the purpose of the law. Because each word mentioned in the purpose, you will have related provisions in the act. Now let's look at the provisions of the Act. The first question that we are going to answer here is, it says SC ST Atrocities Act. So, who will file a case against whom? One, who will be considered as a victim under the Act? Against who can be the offender? If it is an SC, he can file a case against a OC, and if it is an ST, OC, BC and SC. Okay, this is the first one. Please remember, an SC will file a case against OC, BC, ST, OC, BC and SC. Now, what will be the basis for complaint? Please remember, under this law, the complaint can be launched only if it is identity based offense or identity based crime. Now, what is this identity based crime or targeted offense? We use these technical terms. What do you mean by this? It means identity based means, see, you don't have anything against that individual because of his person or character. You have a grudge against him because of the community he belongs to. So basically, identity based refers to the community. Individually, I have no problem with him, but I have a problem with his community. Because he belongs to this community, he becomes a victim of the offense. So the offense should be committed in view of the community and not in view of the individual. Please remember, we call it as identity based crime. The same logic applies when you talk about communal violence. Okay, you commit that violence against the person because he belongs to this community, not because he is a good person or a bad person. Individually, he is not our criteria. His identity as with this community is our criteria. Okay, now the third thing is, if at all a complaint has to be launched, who will investigate into the complaint? If it is city, it will be ACP and above officer. If it is a district, it will be DSP above. Why this? Why can't it be lower level? Because of two reasons. One is, these officers understand the seriousness of the issue, which means scope of negligence in the issue is very, very limited. Scope of negligence becomes limited. Why can't you be negligent in this? Because often such incidents turn into major violences again between the community. So you avoid all that. The second is, influencing these officers will be difficult. Influencing is difficult. It is easy to influence an SI or a CI. It is not that easy to influence an ACP or a DSP. These are the two reasons why you always, in certain important laws, you say this cadre and above. Okay, now the next question is, what will be the different crimes? As I said, crimes under this law are categorized into civil offenses and criminal offenses. They are categorized, and punishment is also graded. Okay, the minimum you'll find is 6 months punishment, and the maximum is very important. There can be death penalty. Okay, please remember, minimum is 6 months, maximum is death penalty. The next one, we talked about which court will be designated as a special court. The law says any court of sessions. Have you heard of a sessions court? Any court of sessions or above can be designated as a special court under the Act. Once it is declared as a special court under SC Atrocities Act, it will take cases, only those cases related to the act. But what level courts? It will be session courts or above. Okay, make a note of these 5.